go in the deep end. And if you would like to introduce yourself, Cara, we can get started.
I'm Cara Wieneke.
Okay, and so I invited you on here because I will be at the dentist while you're doing opening oral arguments, because
You won't
that
miss
seems to
much.
be, well, so the Delphi case is all the crazy, but what kind of drew you into this case other than the fact that Judge Gull has seemed to go completely off the reservation in her judgingness? Now, I am not a lawyer, but have you ever seen anything like what she's done in all your years?
Not in Indiana, no. Apparently, in other
Okay.
states, attorneys can get removed, but I personally have never seen it in Indiana. We only know, or at least I only know, of one other case where it was done, where it was not a conflict of interest with the client, and that was also one that Judge Gull had done. So it's rare to say it, if not unique, especially given the uh, publicity surrounding this case and the craziness, of course.
Okay. She's also seemed to shown a pervasive kind of disdain for any defense motion. I mean, is this something that she's always shown in other cases? Or, I mean, this, having followed the case from the probable cause affidavit to everything else, she does seem to be she does slow roll the defense motions while kind of rubber stamping the state motions. I mean, is that something that goes on a lot in just regular cases, or?
From a defense attorney perspective, yeah, we lose all the time. It's rare that we win anything. I'm trying to think, though, of what issues or what motions the state has really filed in this case. They've done a few things, but most of the motions that have really gotten attention came from the defense. So,
Yeah.
and we're expected, well, if there's justice, you expect that you're going to lose a lot if you're a defense attorney. At the same time, though, from the minute this case started, when they first arrested him, it's been handled completely differently than what you would see in any normal case.
It,
I mean, yes, initially when the charging information and the probable cause affidavit are filed, they're usually confidential because they don't want to tell the defendant, we're coming to get you.
well,
Right?
yeah.
That's not unusual. But the minute that that guy is arrested, then usually they open it up. We have a right as the public to know, what's he being charged with? What are the allegations? What kind of evidence do you have on him? And you'll remember that was shut for almost a month, I think, 20 days,
Yeah.
something like that. Highly unusual. Never seen that in my, 15 years, 18 years of practice. And so initially that decision wasn't made by Judge Gull. And if I remember right, there was an initial hearing held that I don't think anybody really even knew took place until afterwards. And then when
Yeah.
it took place, there was a very bizarre order that I'd never seen before, of sort of a court feeling overwhelmed by the response that he had received to publicity.
Yeah.
All of that following one of the craziest press conferences I've ever seen, where, the sheriff or somebody's invoking God. The state police superintendent was crying, you know,
Yeah. This,
that was a red flag. I thought they are trying so hard to convince everybody that this man is guilty, that made me think, what in the heck do they have? And then when we finally got to see it, it was a nothing burger, quite frankly.
okay. eh, I, so I guess that's where I'll start. When you saw the probable cause affidavit, I know I texted you when I read it, and I was like, what am I looking at? Are you reading what I'm reading? And did you see where a purple PT Cruiser turned into a Ford Fusion? What are we
Right.
looking at? I,
Biggest
I
glaring thing I saw was we had apparently eyewitnesses who saw the man, the bridge guy, at some point after the offense occurred or just before. And I noticed that none of those witnesses, as far as I remember, in the probable cause affidavit, identified Mr. Allen as the Bridge.
Yeah.
That would have been the thing I was looking for. My guess is maybe they couldn't identify him, and that's fine. That's not all that unusual. Time has passed. It just was something that stuck out. I thought, okay, so they don't have an actual eyewitness identification. They've got this piece of forensic evidence that's at best marginal, but most people on my side of the aisle think it's junk science. And
Yeah.
so, that didn't persuade me. So we really just had, again, a whole lot of nothing. And then to see that he was charged with felony murder as opposed to murder, I knew exactly what the state's doing there. They're lowering their burden of proof a bit and saying, oh, we don't have to prove that he killed them. We don't have to prove that he intended to kill them. We don't even have to necessarily prove he was there. We just have to prove he was somehow involved in the kidnapping. And that's a
Okay.
much different burden of proof. When I saw the charge, and I thought it was weird that they had made the charging information confidential. I've never seen that. And so when they finally made that public, I thought, this is interesting. This explained why at the press conference they said, we're still looking for other suspects, things like that. Yeah.
That's been the really weird thing is the state is holding two opposing views at the same time. They are saying he definitely did it by himself, but there also might be co-conspirators. It's very odd. And might we just say that the Miami Vice look is not great, state prosecutor. Not that you can speculate, but I can, and stop it, sir.
And I assumed, okay, they're only giving us a little bit of what they have. They're holding back facts that, maybe if more suspects come forward, they would be able to sort of check to see, corroborate their statements if they hold back these other facts that they have. I don't know. That's something that the state can do. They can put forward just enough they think
Yeah.
they get over the probable cause hump, without showing their case. So I assumed, okay, that's maybe what they're doing. We're kind of trudging along. We're not getting any information really, right? Because everything's sort of kept confidential.
Yeah.
Yeah. But
What
I think the first month, there was a lot of speculation about what in the heck, you had people that immediately almost divided into their two camps. And then defense counsel came out with the press release, which I thought
yeah.
was certainly strategically a smart idea.
Okay, now I did have a question only playing a lawyer on YouTube. What was so wrong about them doing that? It does seem like a double standard as far as the state can have every single press conference with the crying sheriff and the state, and the fact that the defense can't even put out, Richard Allen doesn't have this, 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 and this. Why can't he put out statements of proof just like the state has put out a probable cause affidavit? It just seemed like an unfair playing it field to
Here,
me.
so lawyers themselves have an extra ethical obligation that they cannot, if they are representing a client in a proceeding before trial, especially, they're not supposed to be making statements that are meant to prejudice the potential jury. Um,
Okay.
so the sheriffs, the cops, can make those statements. But you'll remember that the prosecutor at the press conference, he laid out what he had, but he had to say, but remember, Mr. Allen's presumed innocent. And so the problem that we had in this case, though, is that we don't usually have cases that have this level of scrutiny. They're going to have a hard time finding a jury in Indiana
Yeah.
anyway, right? Because we've all heard about it. We're listening to podcasts, everything. So, but
Yes.
it just seemed like there was so much one-sidedness up to that point that really, defense counsel felt, hey, we've got to remind everybody our client still has a presumption of innocence. Let's not convict him before he's ever even been to a trial. And so I think
Yeah.
that was the purpose of that statement.
Okay. So, and then that's when they put out the almighty gag order on everyone and really locked everything down until the document dump in June. I mean, because most of the document dump is every single media agency asking for for clearance to get any of these documents. And that was the first sort of Supreme Court issue. And it seems like the Supreme Court kind of told Judge Gull that she had handled that a little bit inappropriately, but said that it had been resolved thus after the fact. So generally after cases, are they supposed to sort of open things up to the public more so than this case has been, because this case has been radio silence.
Right. And I think the radio silence, we see what happens. It's been a great experiment to see what happens if you don't open it up. And you've had speculation, leaks, conspiracy theories, all sorts of stuff. And so, in my opinion, that's even made it difficult to see whether either side at this point is going to, be able to really feel like they're going to get a fair trial with an impartial
Yeah.
jury. I think they'll still be able to do it. I talked to people who have never heard of the case. You know, I don't know how, but they haven't. So there are 12 people out there.
Yes.
But yes, the gag order, it was interesting because the gag order went in place. I was like, okay, we're not going to hear from defense counsel anymore. Fine. And then it was like radio silence. And I thought, when they started filing things confidentially, I was like, why isn't the media stepping in? Because that, to me, I thought they would have been the ones most upset. And then finally, because everybody knows a gag order response, it applies to your speech, not to your writing, not to your filings. And so I was expecting them to kick in. And when they finally did, I think they were the ones that finally filed something, or maybe even Murder Sheet filed something. That's
Yeah.
when sort of they opened it up to the data dump. But the data dump was difficult, as you know, because once you went to it, you couldn't make anything out. If you're
No,
not
it took
used to
me
looking at things, yeah, you're just looking at a bunch of random documents.
it took me a month to put it in chronological order and then to figure out what half of it meant, and
Right.
most of it was just the media filing, like, "Can we please look at these documents?" And
And the
then
exhibits didn't go with the motions. There were
no.
proposed orders that are confusing to people who don't know we have to submit these proposed orders. So I applauded the fact that it was released, but just the way it was, it took a lot of work to figure out everything up to that point.
Yeah.
And then we still, after that, still had things being filed confidentially without there being. That's the other thing. Our Supreme Court has done a very good job of laying out, hey, if you're going to make something confidential, these are the things you have to do in order to do it. And one of the things is you have to tell John Q. Public, if they go in there, why is this confidential? What statute or rule does it fall under?
Yeah.
Almost nothing was filed with that. I think the state was routinely filing them, but not, I should say the state was filing petitions for that, but they weren't, I think the petitions themselves were confidential. So we couldn't even look and see what reasoning they were giving. And so none of it really, it made it very hard to be able to follow the case. So a lot of times I just kind of, wasn't following the case unless it was something was being reported by the media. But I think things really took a turn with the Franks memo because
Yeah.
clearly people were following the case. And then as soon as something
Yes.
got posted, they were grabbing it quickly. Um,
Yeah.
yeah. And that's when I feel like sort of all hell broke loose. Was they grabbed it. It was shared by, I think, some Tribune or somebody. Anybody could
Yeah.
read it. And at that point, cat was out of the bag.
And I will say the Franks memo and the memorandum that the defense, when it first dropped and I first read the first couple pages, I was like, you guys, I want to like you, but you went full man bear pig and oh my God. But,
It was
and
crazy.
yeah, but then they went through and I love a footnote, and they were using the discovery from the state, and it really painted a picture. I think the part that sold me, at least on reasonable doubt, was just the chronological, and unfortunately, you do have to go into the sort of physicality of what happened to these two young girls. But for this short, not very athletic man to do all of this during a time where he could get caught. I mean, this is a very high risk crime. This is a highly traveled path. This is an unseasonably warm day. People are coming and going. It, it just doesn't make sense that this is his first crime. He just goes out there. None of this makes sense. And I'm not saying that person can't go out and just go full on crazy one day,
Right.
but it just, you have to sell it to me. And thus far, what the state has put out, and they might have more behind the scenes, but what they have put out thus far doesn't sell me on one person being able to do this.
It was, and I'm trying to remember if it's been so long since I read some of these pleadings, but I thought that the defense had sort of um, tickled us a little bit with some facts about the problems they were having visiting with Richard in I think it was Westville at that time, and they kept
Yes.
talking about they had one time they were being filmed, and I
Yes,
thought that came out in April of 2023 in that
I
filing,
believe so. And
and
there was
so
a, a restraining order put on them that they could not be filmed. I,
right. And
I
there
have
was
never
there was
heard of
talk of
this.
patches, but we didn't know what
Yes.
the patches allegedly were. And I'm thinking to myself, okay, I've been to Westville several times. I've been to all the DOC institutions. I've never been filmed. And I was thinking, what would I do if I were filmed? Would I stop them? Would I be like, what are you doing? Um, you go inside a prison, even as a lawyer, it's a very different, you don't get to tell them what to do, right? They can kick you
Well,
out.
yeah.
And honestly, what are you going to do about it? People say, oh, you go to the ACLU. They're not going to mess with that for one person. So you're really out there. If they decide if they want to tape you, I mean, I guess they're going to film you, right? But I've never had them do that. And so this was completely bizarre. And I'm thinking patches. I don't look at what correctional officers wear. So I started thinking things were weird at that point. And then we had the Franks memo, and I was like, you know, this is bonkers, right?
Y- yeah.
100 and some pages. I've seen memos filed that long, but not in sort of a pre-trial manner where, and of course people ate it up because we had not heard
Oh,
anything.
yeah.
Yeah. So,
Well, the state is the state and the judge are complaining about conspiracy theories, but if you don't give us any information, you are creating fertile ground for us to make up our own theories. So it's a dual-edged sword. You either want to maintain complete radio silence to maintain your case, then people are going to start making up their own, because at the bottom of all this is a deep desire to get justice for these girls.
right,
So it comes from a good place, but people want to feel like something is being done, because for the last 5 years we've gotten two different sketches and then two janky recordings where we added one word, guys, down the hill. It feels like we have gotten really nothing from this investigation and now this, you know, trial or this court case. So people want to help, people want to get justice. And what I fear is that if Judge Gull is allowed to stay with the prosecutor or with the defense that she has handpicked, no justice is going to be served, because you are going to have either ineffective counsel, and he is going to this is going to be appealed, and the family is going to have to go through this again, or he is going to be found innocent and people are not going to understand because they're going to say they had him dead to rights. I don't get it. That's my worry.
And honestly, that's a little bit of an argument for why there should be cameras in the courtrooms, especially in high profile cases. You can think of some of the more high profile trials we've watched on LawTube, and people can come to different conclusions on the evidence, but at least they're all understanding the evidence as being the same. Whereas if you have a very secretive proceeding where you're not able to go in and look at all of this, I mean, you take something as simple as the description of the crime scene, and I don't know if the description that was given in the Franks memo is correct because I've not seen anything. I have no clue.
Yeah.
But at some point, somebody was going to see it, and that would have been in a very public jury trial. And I understand the concern about not inflaming the jury, not poisoning, tainting the jury pool. But a lot of these people who are really invested in this case aren't going to be on the jury because they're going to
No.
be asked, do you follow this case? What have you heard? And as soon as they say, truthfully what they have, they're going to be off. And it, so that's sort of the thing. People who are following the case aren't going to be on the jury, but you can't keep everything secret in the hopes of, I guess, maximizing that number of people because it doesn't work. Conspiracy theories, podcasts, everything's popping up. People are still learning things. It may not be what is true.
Well, I mean, we didn't even know how the girls were murdered for
Right.
years. I mean, when we
We
heard that there
had,
was
who was it? Was it somebody, Fox 59 or somebody Russ McQuaid broke a story about a search warrant. I don't remember if it was the guy whose
oh yeah,
property. And all the search warrant said something about a lot of blood, but it was at a different place. So I assumed probably a knife was involved.
but then they started saying something about a gun, so I thought, "Oh, they
Right.
must have been shot." So we didn't even know until the Franks memo that they had been, stabbed or that kind of thing. And I guess the Franks memo brings us to the leak gate,
Right.
which what a shitty friend. I mean, like what a schmucky move.
Yeah. People have just lost their minds with this case, though.
Yeah, but also whatever would motivate you to take pictures of young girls that had been horrifically posed.
Right.
Sir, Snake Island, and you need to maybe check your Jesus levels cuz I don't know about you. But that being said, is that something as a lawyer, are you supposed to have that kind of evidence in a locked area? Is that something that is standard operating procedure? Or do you have like a war room? I guess, are these things that they teach you in lawyering school? I don't know.
Well, trial counsel tells me, or at least trial attorneys tell me, yes, they generally in bigger cases do have sort of a war room where they'll work everything. They put up their picture boards and all of that. If you see on movies, so they will do that. How much security they have, though, it depends. Yeah, they shouldn't have it to where anybody walk in the office could get in there. Having said that, though, do they have to have it under lock and key at all times? If it's back in an area, if I understand right, it's back in an area, there's a private conference room that only a limited number of people should go. That's the thing. It's regardless of whether or not a mistake was made. It was
Yeah.
not intentional. It was an accident.
Yeah.
My feeling on it was who wants to look at these pictures where we have a description, pretty
Yeah.
pretty detailed in a memo.
I,
Do I need to know? Um,
no.
I can picture, I can Google these examples that they gave. Do I need to actually
Yeah.
see it? Can I wait till the trial to see it then? You know?
Yeah. So I guess I kind of went full Dale Gribble on the whole thing because it seemed to me like the two biggest thorns in the state and Judge Gull's side, murder sheets and the defense, kind of in one fell swoop, you kind of link them in sort of shenanigans, and you can discredit and malign them as, not respecting the victims, being poor stewards of the evidence, and, terrible, horrible people. Because I cannot tell you, I was racing home to get to the hearing, and all of a sudden you hear, there will be no hearing. Judge Gull comes on, and she's like, due to unforeseen whatchamacallits, we're, not having a thing. And I text you and I was like, WTF is going on here? I hauled butt to get home. And you said, I, there is something going down. And then to read the transcript of what was going on, not being a lawyer, how unusual was the in chambers sort of behavior, or I guess hearing? I mean, there are due process sort of ways that you would, in fact, remove a lawyer, correct?
Yes, if there's a conflict of interest or something, you usually have a hearing on it so that it can come out. Um, and so the fact that Mr. Allen wasn't back there, certainly, that's unusual. It's not unusual to have in chambers hearings. There are judges that like to have you come in there first, tell them what you're going to do so that they know what to expect. They know what they need to prepare for. That's not all that unusual. Obviously, though, this one was different because it seemed like the parties they had an idea of what they were coming in there for, but I'm not sure that they knew the extent of what was going to happen. And then, of course, everything's on camera when she does come out there. And it was, I, up until not too long ago, did not realize that Mr. Allen wasn't in the courtroom that day either on the camera. I thought he was sitting there by himself, and I was pretty upset that he was sitting there by himself. And so I kind of expressed a little frustration to my husband, like, why would anybody leave him sitting there alone? That's such a bad look for this guy clearly is overwhelmed by what's happening, regardless of his guilt or innocence. He does,
Yeah.
he's entitled to have representation. He's sitting there by himself. So
Now, it did seem that the judge and the state's attorney had talked about, removal of the defense together. Is that something that the judge and the state's attorney can talk about together and kind of formulate a plan without talking to the defense attorneys?
no, that would be unethical. I don't know. From what I understand, that didn't happen. Like, defense counsel was aware that this had, like, the idea had been thrown out, that was a possibility. I think that they were in shock, just like a lot of other people were. Like, this isn't something that we normally would allow you to do in Indiana. We just don't do it. I mean, yeah, you can have conflicts of interest where if you're representing co-defendant at the same time, the judge will come in for a very public hearing with your client, say, you can't represent both of these people. Uh, I've never had a situation like this, though, where there was discussion about, we don't think you're competent, or that you're going to represent him well, especially given everything that they'd done up to that point. So that's what I
Now,
think
what
was so
was
different.
the tort issue? Or I know that there was a conflict of, or a tort issue. Can you explain that? Because it kind of seemed like I looked it up, but it didn't make sense.
Yeah. So if you're confined in prison and you feel like they've either injured you physically or denied you medical care or something like that, you can sue them for that. But before you can sue certain institutions of the government, you have to serve them with a notice that you believe you have a tort
Okay.
claim. It has to be done within a certain amount of time. I don't do tort claims, so that's about the extent of my knowledge of it. But from what I understand, when Mr. Allen thought he had a tort claim, he wanted to file a notice. He's not a lawyer, so he didn't really have one of those forms you can fill out. Now, other
Okay.
prisoners can go into the law library and get one, but from what I understand, he
He's
wasn't able to do so. And so one of his attorneys filed it on his behalf. Didn't mean that he was going to represent him or anything, just simply it's kind of like a, hey, here's our notice. You've complied with this. If you want to get a lawyer to sue, you can. You've
okay.
overcome this little
All
threshold.
right.
Yeah.
That was the one thing that I understood where she was, at least her reasoning on everything else, sort of, but I didn't understand the tort claim. I was like, maybe he has civil, he's suing Grubhub. I knew they didn't deliver. Jimmy John's was not coming into.
And if he were private counsel, I don't think this would come up. But as a public defender, yeah, if you have a case as a public defender, you're not supposed to be able to try to parlay that into a paying job type of thing. However, if somebody accuses you of that, that's usually an ethical
Okay.
complaint that they have, and not one about your performance, so to speak. So,
And I guess that segues into my next question. Now, what you were telling me is when she did dismiss the lawyers, there was a mechanism by which she could have gone through the entire state or a pool of state defense attorneys. Now, she chose to go with Allen County state attorneys or defense attorneys, and she chose to pick two of the most interesting characters. Why?
we don't know because they didn't really answer that question in their response. What should have happened, because this is always a Carroll County case, this has always been, and Carroll County has their own public defenders. What should have happened is that the case should have gone back to the public defender in Carroll County to decide if he or
Okay.
she has anybody who's qualified to do it. And if they didn't, the judge could have also sent it on to the state public defender, and the state public defender has a list, and she would have been able to select somebody off the list. To do it this way, I mean, there has been a lot of chatter online about, and it was in the amicus brief. Here's really what should have happened, and now the two counties are kind of in a quandary because you've got your chief public defender who's 100% employed with Allen County spending time on a Carroll County case. If I were an Allen County public defender, I wouldn't be really happy about that. I'm sorry, if I
Yeah.
were an Allen County taxpayer, I wouldn't be really happy about that. At the same time, if I'm a Carroll County taxpayer, I've got to pay these two lawyers to start over again, to redo everything Brad and Andy have already done.
Yeah.
And it's going to be an expensive redo. So, again, I can understand where the chatter's coming from. This is unusual. We thought that it did not follow the law, what you're supposed to do by law whenever you've got a situation like this, when you need to appoint counsel and you're a special judge.
Okay, now following that vein, I know that our AG and the judge have been very critical about the fact that, you know, uh, his now former defense, but his pro bono defense right now did not go through what they considered the appeal sort of process that they found, but from what I understand about it, they could not go through the appeals process until after this new trial was completely done
Well,
to appeal their.
you can get an interlocutory appeal when interlocutory means intermediary. So you can get an appeal in the middle of a trial proceeding, if the trial judge agrees and if the Court of Appeals agrees. Part of the problem we had in this case, though, is that whenever old trial counsel attempted to file anything, it was being removed from. So you have to file everything in the trial court in order for there to be an appeal. At least that you have to meet that threshold before you even go to the Court of Appeals.
Yeah.
And so that was certainly a problem. Also, timing is, I mean, even at the quickest you can go in an interlocutory appeal, 6 months, 3 months would be really pushing it. And so you here, Mr. Allen's still sitting without his jury trial, right? For another three
Yeah.
to 6 months. A lot of people think that this process is taking more time than they would like. It's still the quickest, most efficient way to get to the bottom of this and to get a final answer. Supreme Court, that this is
Yeah.
it at this point. And so it just is the only avenue that Rick really had if he wants to get to his trial.
Now, I know that there's been some scuttlebutt here about now, is Mr. Allen going to be at the oral arguments, or are we just being told that, we don't know how to move a prisoner? Are we confused?
I don't know where that came from. If we wanted Mr. Allen there, it probably would have been on us to file the motion for transport. But co-counsel and I talked about it, and we talked about it with Mr. Allen, and we were like, look, it's going to be live streamed. It'll be available for replay later. He can't testify. He can't really do anything but sit there. Every single time they move him, it's a risk to him and to even some people would say to other people. And so, it just made no sense to have him transported. And he was in agreement with that. So when we heard this, I was like, this is odd. Where is this coming from? I didn't know if something was being done that I didn't know about. I suppose that's why I checked with the Supreme Court services to see if maybe the Supreme Court had wanted him there. Because certainly if they want him there, I'm going to defer to them. But it sounded like that they had not asked for him on their own to be there. So and again, going back to, not that this case isn't unique and we wouldn't expect things to be handled differently, but I've practiced almost 20 years. I have never seen a defendant who was incarcerated in an oral argument. They just generally don't. Yeah.
Kind of on that vein, how is Mr. Allen doing in the new prison? I see that the Supreme Court was very okay with him moving fairly quickly. So I guess, Judge Gull seems to have been overridden in that.
I think he's doing better in some respects because,
Well,
yeah, but better and not.
I'm,
You know,
yeah.
every time a prisoner moves, an issue. Could you imagine? Because they don't
Yeah.
get noticed. So somebody shows up and they're like, "Get all your stuff, and whatever you can't get, we'll ship." And sometimes it gets there, and sometimes it doesn't. A lot of times you have to start things over again. You have to get new approval for phone calls, visits, things like that. And so every time you move, it's not a good thing. We weren't told a lot, and we were pretty much told that we aren't his real lawyers. So we can't get any information anyway because we're not representing him on that case, that
Oh,
kind of thing. That's the game that's being played. So we did talk to him, and we have communication with his wife. So we have some ability to make sure he's okay, obviously. So that's about all we know.
well, thank you for taking time. We've got about 45 or 40 minutes. I am going to put an end video on. So thank you. And I will probably talk to you more after you've done the oral arguments. I will be
Definitely.
doing a not live stream because I'm in love with my dentist. So give me 1 second here. Wait, end this.